Welcome to the Supreme Court of the United Kingdom. Today we're hearing the appeal in the case of Uber against Aslam and others. This is a case concerned with Uber drivers who claim that they are workers for the purposes of employment legislation and on that basis are entitled to the minimum wage, paid leave and other legal protection. Uber, on the other hand, argue that the respondents are not workers, but independent third-party contractors. Because of the coronavirus problem, we're hearing this case remotely. I'm sitting with 6 of my colleagues, whom I'll introduce now. First, Lord Hodge. Lady Arden.
Good morning.
Lord Kitchen.
Morning.
Lord Sales.
Good morning.
Lord Hamblin.
Good morning.
And Lord Leggett.
Good morning.
The appellants, Uber, are represented by Ms. Dinah Rose, Queen's. I'll invite Ms. Rose now to begin her submissions.
May it please the court, I appear with Mr. Campbell for the appellants, and my learned friends Mr. Galbraith Martin and Mr. Meary appear for the first and second respondents, and Mr. Siegel and Ms. Tether for the third respondents. As my Lord Reid has just indicated, there are 2 issues in this appeal. The first is whether the Employment Tribunal and the Court of Appeal erred in law in concluding that the claimants were what is known as LIMBY workers employed by Uber London Limited. The second issue is when, if the claimants were LIMBY workers, they were to be taken to have been carrying out their work. And obviously the second issue arises only if we are unsuccessful on the first issue. The first issue will take up by far the larger part of my submissions, and it involves in turn a number of questions which the court can see summarised in the statement of facts and issues. I don't intend to go to it, but for your reference, it's at pages 76 to 77. You can see that we've enumerated there the issues that arise under issue 1. So without any further ado, I'd like now to turn to issue 1, which is going to be the main focus of my submissions today. And the way that I intend to proceed is as follows. First, I'm going to outline the legal framework, including the test to be applied in order to determine whether a person is a LIMBY worker, the role of an appellate court in an employment tribunal appeal, and the proper approach to construing contracts in a context such as this. Next, I'm going to show the court the written terms that were agreed between the claimants and Uber, and the written terms that were agreed between passengers wishing to use the Uber app and Uber. And those terms are all going to be the terms that were applicable at the material time, which is 2016. I should stress that there have been some quite significant changes to the terms and conditions subsequently, but this court is only concerned with the position as it was at the date of the tribunal hearing. Then I'm going to show the court the findings of fact that the tribunal made about the way in which the relationships operated in practice. Then I'm going to make my key central submissions, which are as follows. First, that the way that the app and relationships between the parties operated in practice was no different from the substance of the rights and obligations as they are set out in the written terms. There is no inconsistency between what the parties agreed in writing and what their conduct shows them to have understood their contractual rights and obligations to be. Then the second submission is that these rights and obligations, which are reflected both in the written contracts and in the way that the parties conducted themselves, are themselves consistent with the characterization of the relationships in the written terms. In other words, with the concept that the claimants contracted with Uber BV, that I'm going to call UBV, for access to the app under certain conditions, and contracted with passengers to provide driving services to them through Uber London Limited, the licensed private hire vehicle operator in the London area, operating as booking agent, as was required under the local statutory scheme applicable to London. And on the basis of those two submissions, our overarching submission is that Lord Justice Underhill was correct to conclude in his dissenting judgment in the Court of Appeal that the Employment Tribunal had erred when it found that the claimants were LIMBY workers employed by ULL on the basis that the written terms were fictional and should be disregarded because we say, on a proper analysis, the written terms were wholly consistent with the operation of the contract in practice. So after making those submissions, I'm then going to take the court to the Employment Tribunal's judgment and identify what we say are the various errors of law in that judgment. And finally, I'm going to do the same for the majority judgment in the Court of Appeal, which contains some somewhat different errors. Some of the Employment Tribunal's errors were identified, but different errors were substituted, including what we submit to be an erroneous interpretation of this court's decision in Autocleanse and Belcher. Now, a short summary of our case is simply that we say that Lord Justice Underhill was right for the reasons that he gave. I'm not going to take this court through his judgment in detail, but we do adopt its reasoning and submit that it is correct. So with that short introduction, that brings me to my first topic, which is the legal test. The principal claims that we are concerned with in this case are claims for entitlement to the national minimum wage under the National Minimum Wage Act 1998, and claims for holiday pay under the Working Time Regulations. There is in addition a single whistleblowing case brought by Mr. Aslam under the Employment Rights Act. Now, the applicable legal test that we are concerned with is set out, first of all, in the National Minimum Wage Act, which is at page 699 in the electronic bundle. And if you go to 699, you can see section 1 of the Act, that a person who qualifies for the national minimum wage shall be remunerated by his employer in respect of his work at a rate not less than the national minimum wage. And a person qualifies for the national minimum wage if he is an individual who, A, is a worker. So the first requirement is that you must be a worker. And worker is then defined, if we go to page 705, this is section 54, meaning of worker and employee, etc. And first of all, you see the classic definition of an employee, somebody who works or worked under a contract to employment. And then at 3, worker, except in the phrases agency worker and home worker, means an individual who has entered into or works under, or where the employment has ceased, worked under, A, a contract of employment, or B, any other contract, whether express or implied, and if it's expressed, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract, whose status is not, by virtue of the contract, that of a client or customer of any profession or business undertaking carried on by the individual. So what we see is that a worker is defined by reference to a contract. A Lim A worker is simply somebody who is working under a contract of employment. And as the court will know, there is a mass of case law about what the elements of a contract of employment are. But a Lim B worker, which is the concept we're concerned with, is also defined by reference to a contract, and a contract under which a party has undertaken to do or perform certain things. There are three elements in our submission to a Lim B contract. First of all, the individual undertakes to do or perform work or services for another party to the contract. So there must be an agreement to work or perform services to somebody who is a party to the contract. Secondly, the agreement must be an undertaking to perform that work personally. And thirdly, the status of the other party to the contract cannot be that of a client or customer of any professional business undertaking. So the first point to note in our submission is that Parliament has chosen to define the scope of entitlement to the statutory right to a minimum wage by reference to the existence of a contract that has these particular features. Protection is triggered by a contract with these features. And as we noted in our written case, this formula is not a recent formula. It can be found in legislation going back into the 19th century. So if there is no contract between an individual and the alleged employer, or if the contract between them is not a contract under which the person has undertaken to do any work or services for the other party, then the individual is not a worker within the scope of this definition. The conditions have to be satisfied. They are exclusionary barriers in the sense that these features of the contract mark the boundary of what Parliament has decided should be the ambit of the statutory right. And the existence of these features can only be detected by construing the terms of the contracts that govern the relationships in question, and then by asking the question whether those contracts, properly construed, meet the conditions of the statutory definition. Putting it another way, these conditions in Lim B define the extent to which Parliament has chosen to interfere with freedom to contract in this context. If the statutory definition is met in a particular case, yes, sorry, my lord.
Sorry, I had to wait to be unmuted there. We don't have in the bundle section 49 of this Act and the equivalent provisions of other acts which preclude parties from contracting out.
Yes.
But is that not a relevant consideration to take into account in deciding, in working out how this statutory framework applies?
My lord, that touches on a point I'm about to reach. Let me just answer your lordship's question now, though. If you conclude that on a proper construction of the contracts, they fall within the ambit of the statutory scheme, i.e. this is a contract of employment or it is a contract that has the Limb B features, then the statutory scheme is that the parties cannot contract out. So once you've concluded that this is a contract that falls within Limb B, the parties cannot agree that the worker will receive less than the minimum wage. That's the point. But in my submission, what Section 49 doesn't do is to warrant a special interpretation of contracts that parties have entered into in order to bring them within the scope of Limb B. Because there is a difference between the question, is this a contract that falls within the scope of Parliament's scheme at all, the question we're concerned with, and the question, if this is a contract that falls within Parliament's scheme, are the parties seeking by particular terms to contract out of the statutory protection that Parliament has laid down for those types of contracts? And it is a critical distinction. It's one I'm actually about to turn to, my lord. So I was coming to the question of freedom to contract, and it's closely related to your lordship's point, because the point I want to make is that if the statutory definition in Limb B is met in a particular case, then Parliament does indeed interfere extensively in the parties' freedom to contract. Because, as your lordship says, you can't contract out. The employer must agree to pay the employee at least the minimum wage. But the starting point is the contract itself. Parties are free to enter into an agreement that's outside the scope of Limb B. And nothing in this Act of Parliament interferes with their freedom to do that. And in my submission, there's no warrant for adopting a broad construction of Limb B so as to strain to bring relationships within its scope, or any warrant to take a special approach to the interpretation of a contract for the purpose of bringing it within the scope of Limb B. And still on this theme, in my submission, there is a useful contrast that can be drawn with cases such as the case of Bankway. That's in the authorities, it's at page 760. That's a landlord and tenant case in which my Lady Arden gave the lead judgment. And in that case, the parties had avowedly chosen to enter into an assured tenancy agreement. There was no dispute that their agreement was an assured tenancy agreement, and therefore that it attracted the statutory protection of that type of agreement. But what then happened was that one of the terms in that agreement provided for an exorbitant rent review that would increase the rent of the property to a rate far, far above its market value. And what the court found was that this was not a genuine rent review clause at all. Its purpose was to seek to undermine the statutory protection against repossession. It was a device. And the court held that it was a device that was repugnant to the protection under the statutory scheme and therefore unenforceable. Now that in my submission points up the distinction that I'm seeking to draw, because the position would have been very different if the agreement that the parties had entered into had not been an assured tenancy. If the question that the court was being asked to address in that case was, is this an agreement for an assured tenancy or not, then you would simply have been construing the agreement in accordance with its own terms. So in my submission, the principle is that if a contract does fall on its proper construction within the scope of a protective statutory scheme, the parties to that contract cannot include terms in it that are repugnant to the protection of the scheme. However, that principle does not assist if the issue that the court is grappling with is the prior question that arises in this case, namely, whether or not this is a contract of a type that falls within the scope of the protection of the statutory scheme at all. Now, there's an important further point about the scope of the National Minimum Wage Act. The Act itself provides for limited circumstances in which the definition of worker is extended. And if we go back to the Act, it's in page 699, and we've been looking at section 54. If you go back now to page 703, you'll see section 34. And this is an extension of the definition of worker for a particular category of workers known as agency workers. This section applies in any case where an individual, the agency worker, is supplied by a person, the agent, to do work for another, the principal, under a contract or other arrangement made between the agent and the principal, but is not, as respects that work, a worker because of the absence of a worker's contract between the individual and the agent or the principal, and is not a party to a contract under which he undertakes to do the work for another party to the contract whose status is, by virtue of the contract, that of a client or customer of any professional business undertaking. Now, what that is getting at is a situation such as a situation where you have contract cleaners and you have a cleaning agency which has a number of cleaners on its books, and those cleaners are supplied to work to clean an office. And so the contract between the cleaner and the agency is not a worker contract because the cleaners are not performing services for the agency. The cleaners are performing services for the office, but they don't have with that office a contract under which the office is their client or customer. So there you see Parliament expressly extending the statutory definition to catch an identified vulnerable group of workers. Now, as the Court of Appeal noted, that position can't apply in this case. The reason it can't apply in this case is either we're wrong, in which case there is a worker agreement between the claimants and Uber London Limited, which is what the tribunal and the majority of the Court of Appeal found, or we are right, in which case there is a contract between the drivers and their passengers, under which the passengers are the customers of the drivers. And the existence of that contract would take this outside the scope of Section 34 because of Section 34C. It doesn't apply in this case, but in my submission, it's significant when you're considering the proper construction of the statutory scheme and how that impacts on the proper construction of the contracts. Because what this shows is that Parliament's made a legislative choice to extend the scope of Limb B to cover a particular situation. Now, Parliament could, and still could, and indeed there's some political pressure for it to do so, introduce legislation that extends Limb B further and extends it to situations such as the Uber situation, or what we say is the Uber situation. And it may be that in the future, to deal with gig economy and changed patterns of working, that might be a legislative choice that Parliament makes. But it's not the position at the moment. So that's the National Minimum Wage Act. And the second claim that's being brought is a claim for holiday pay under the working time regulations. And the statutory position under those regulations is materially identical to the statutory position we've just been looking at. The working time regulations are at page 695. And the definition of worker is at regulation 2, page 696. You can see it about 2/3 down the page, and you'll see it's in identical terms to the provision we've just been looking at. And then the extension to cover agency workers is at page 698 under regulation 36. You see the same scheme adopted by Parliament in 1998 for both regimes. Now, there's a third claim, which is only brought by one of the respondents in this case, Mr. Aslam, and that is a whistleblowing claim. And whistleblowing claims are brought under the Employment Rights Act, which you have starting at page 690. And the definition of worker under that act is at 693. That's section 230. And again, you can see that it's in the same terms as the provisions we've just been looking at. There is also an extended definition of worker under the Employment Rights Act. And interestingly, it is different from the extended definition dealing with agency workers that we've been looking at in the context of working time and minimum wage. And the extended definition, which you have here, it's at 43K, page 690, dates also from 1998. You can see that if you go over the page and you look at footnote 1, that this was added by the Public Interest Disclosure Act 1998. So in the same year, Parliament has chosen to extend the definition of worker for the purposes of whistleblowing in different terms from the language that it's used in relation to minimum wage or working time. And if you look at 43K, you can see that for the purposes of this part, worker includes an individual who's not a worker as defined at section 233, but who works or worked for a person in circumstances in which he is or was introduced or supplied to do that work by a third person, and the terms on which he is or was engaged to do the work are or were in practice substantially determined not by him, but by the person for whom he works or worked, by the third person, or by both of them. Now that is, on the face of it, a broader definition than the definition of agency worker that you see under the other two legislative schemes. The Employment Tribunal in this case did not consider whether or not that definition would apply to Mr. Aslam on the basis that Uber was correct in its contractual interpretation, because it proceeded on the basis that there was no contract here between the driver and the passenger. And you can see that it's paragraph 99 of the Employment Tribunal decision. We don't need to go to it. But again, in my submission, the significance of this is that it shows that Parliament here has adopted a different statutory formula to capture different categories of working for the purpose of the scope of different statutory rights. And this is obviously a public policy question that is sensitive and nuanced and highly political. We can't really speculate what are the policy reasons why in 1998 Parliament decided that agency workers would get the right to the minimum wage, but Section 43K workers would get the right to bring whistleblowing claims. I can speculate as to the reasons why that might be, but that's not a matter for us, it's a matter for Parliament. And in my submission, and with respect, we say that the written cases of the respondents fall into that error. There is a tendency to invite the court to take a position and say these are contracts that ought to be within the scope of the statutory protection, and therefore they should be construed in such a way as to fall within the scope of the statute. In my submission, that's the wrong approach. The right approach is to construe the contracts in accordance with the question, what did the parties intend objectively? What did the parties agree? And then ask whether those contracts fall within the scope of the boundaries that Parliament's laid down for the scope of statutory protection. We say that that is, in substance, the same question that courts apply, for example, when they're considering tax legislation. The respondents have put a number of tax cases in the bundle. And the significance of those cases, as it seems to us, is that in the old days, there was a tendency to adopt a highly literalistic approach to the construction of tax legislation, and that has now been superseded by an approach that we would recognise as normal in pretty much every other field, which is that you construe the legislation in accordance with its wording and purpose, and then you ask whether a particular transaction, also construed properly, falls within the scope of the statute. So that's what I wanted to say about the legal test for a LIMB worker. And as a matter of fact, this court has considered the application of that test in a number of recent cases. And there are three cases I want to look at in particular. They are the cases of Bates van Winklehoff, Gillam and the MOJ, and Pimlico Plumbers. So can we look first at Bates van Winklehoff? You have that at page 794. A judgment of Lady Hale. And the issue here was whether an equity partner in a limited liability partnership was a LIMB worker. And the Court of Appeal had held that she was not a LIMB worker because, first of all, they held that there was a statutory reason which doesn't concern us under the Partnerships Act, but secondly, that there wasn't a relationship of subordination which they held was necessary in order for somebody to be a LIMB worker. And this appeal was allowed, and the decision of the Court of Appeal was reversed. Now, if we go in the judgment of Lady Hale, first of all, page 798, paragraphs 11 and 12, there is a summary of what the Court of Appeal decided. And then if we go to the discussion at paragraph 16, there is discussion of the statutory question. And then at paragraph 31, paragraph 30, we come to what Lady Hale describes as the more subtle analysis addressed by the Court of Appeal. So this is after the statutory question. She says it's necessary to consider the more subtle analysis at paragraph 71 that underlying the statutory definition of worker is the notion that one party has to be in a subordinate relationship to the other. And at paragraph 31, she points out the three different types of people identified under employment law: contract of employment, self-employed and a business on their own account, and an intermediate class of workers who are self-employed but don't fall within the second class. She then refers to discrimination law, where there is a slightly different phraseology. Discrimination law doesn't talk about people employed under a contract of employment. It simply talks about those employed under a contract personally to do work. And she points out that there is actually no difference between that definition and the definition of worker in substance under this legislation. Now that's significant because we'll see at a later stage today that one of the errors that the Court of Appeal makes in this case is that it seeks to distinguish the case of Mingley and Pennock, which we say is directly relevant, on the basis that that was a discrimination case, and it says it was considering whether someone was an employee, not whether they were a worker. But there is no significant difference between whether someone's an employee for the purposes of discrimination law and whether they're a worker for this regime. So then Lady Hale refers to the case law on workers, and in particular, you can see that she refers to the cases of Cotswold Developments and James and Redcats. Now, those are cases where the issue was whether the third condition under Lim B was satisfied. The court will recall that I've identified the question. Firstly, are you working for the other part? Have you agreed to work for the other party to the contract? Secondly, have you agreed to perform that work personally? And thirdly, is the status of the other party to the contract other than that of client or customer? And these cases, Cotswold and James, are concerned with the third of those elements. It's in that context that the question whether or not a person is subordinate or integrated into the business and the question of degree of control becomes relevant. You're asking, is this a relationship between a business and a customer or between a worker and an employer? That issue is not relevant to this case, not the question. The question in this case was simply whether there was a contract under which the claimants had undertaken to perform any work or services for Uber, or whether, in fact, they were contracting to provide services for passengers. That was the question. So the whole question of integration and subordination and control was by the by in these proceedings. And that's one of the reasons I'm going to submit that the heavy reliance of the courts and tribunals below on this case law, Redcats and Cotswold, is misplaced. Now, she sets out the reasoning in those cases, and then she deals at paragraph 37 with a judgment of the Court of Appeal in Hospital Medical Group in Westwood, and the judgment of its Lord Justice Maurice Kay. And at paragraph 38, Lord Justice Maurice Kay pointed out that neither the Cotswold integration test nor the Redcats dominant purpose test purported to lay down a test of general application. In his view, they were wise to eschew a more prescriptive approach, which would gloss the words of the statute. And then a little further down the paragraph, this was the right approach. The fact Dr. West was in business on his own account was not conclusive, because the definition also required that the other party to the contract was not his client or customer, and HMG was neither. And then Lord Justice Maurice Kay concluded by declining the suggestion that the court might give some guidance as to a more uniform approach. I do not consider that there is a single key with which to unlock the words of the statute in every case. On the other hand, I agree with Mr. Justice Langstaff that his integration test will often be appropriate, as it is here. And then she says, I agree with Lord Justice Maurice Kay that there is not a single key to unlock the words of the statute in every case. There can be no substitute for applying the words of the statute to the facts of the individual case. And in a sense, that is our whole submission in a nutshell. There will be cases where that's not easy to do. In my view, they're not solved by adding some mystery ingredient of subordination to the concept of employee and worker. The experienced employment judges who've considered this problem have all recognised there's no magic test other than the words of the statute themselves. As Mr. Justice Elias recognised in Redcats, a small business may be genuinely an independent business, but be completely dependent on and subordinate to the demands of a key customer. And he gives the example there of suppliers to Marks and Spencer's. Equally, as Lord Justice Maurice Kay recognised in Westwood, one may be a professional person with a high degree of autonomy as to how the work is performed, more than one string to one's bow, and still be so closely integrated into the other party's operation as to fall within the definition. As the case of the controlling shareholder in a company who's also employed as chief executive shows, where it can effectively be one's own boss and still be a worker. While subordination may sometimes be an aid to distinguishing workers from other self-employed people, it's not a freestanding and universal characteristic of being a worker. And then we see the actual decision, which was that in this case it wasn't disputed, that the actual limbs of limb B were met. The three conditions were met. On that basis, that was the end of the matter. The claimant was a worker. So we say that, with respect, is the correct approach, and there is no mystery ingredient of subordination. The matter was then considered again by Lady Hale in the case of Gillam and the Ministry of Justice. And this is at page 1441. This is a decision that postdates the decision of the Court of Appeal in our case. The issue in this case was whether a district judge was a limb B worker in the employment of the Ministry of Justice.
And you've taken us to the Court of Appeal decision in the case.
1483, my lord.
Right.
Yes, 1483, I beg your pardon. So the issue is whether a district judge is a limb B worker. And in this case, the Supreme Court found that the district judge was not a limb B worker. In fact, they found that there was a right to bring a whistleblowing claim for other reasons to do with the Human Rights Act, which we don't need to trouble us. The key point is the first finding. And if we go to the head note, you can see what the issue was. And then at paragraph 12, we see the heading, is a judge a worker? This is 1489. It's not in dispute that a judge undertakes personally to perform work or services, and that the recipient of that work or services is not a client or customer of the judge. The issue is whether that work or services is performed pursuant to a contract with the recipient of that work or services, or pursuant to some different legal arrangement. So this is an example of a case where it's not about substitution, it's not about whether somebody is your client or customer, it's about the question whether there's a contract at all. Now, of course, judges are office holders, but the fact that somebody is an office holder does not include them also working under a contract. And there's then discussion in the case about the circumstances in which an office holder has a contract, with reference to some of the church cases some members of this court will recall. And at paragraph 15, Lady Hale refers to the case of Preston and the president of the Methodist Conference about whether a Methodist minister was an employee for the purposes of the discrimination legislation. And at 16, what is said is, it is clear, therefore, what the question is. Did the parties intend to enter into a contractual relationship defined at least in part by their agreement or some other legal relationship defined by the terms of the statutory office of district judge. Now, just pausing there, in my submission, that links back to the point I was making at the outset about the way to approach Limb B and the construction of contracts to decide whether they fall within Limb B. There's no suggestion here that you would take a broad or purposive approach to the construction of this relationship in order to bring it within the scope of Limb B. This is a completely orthodox approach to the interpretation of the relationship between an office holder and the statutory body that's appointed them in order to determine whether their relationship is dictated purely by the terms of the statutory office or whether there's also a contract. You don't take a different approach to that because the consequence of one approach may be that you get protection, and of the other approach that you do not. And at paragraph 17, before we leave it, the point you can see is that the point is about the party's intention, of what the parties intended to agree, which it always is in a contractual position. And the conclusion is at 17. In looking at the manner the judge was engaged, it could be said there was classic offer and acceptance. There was a letter offering appointment on the terms and conditions set out in the letter, an accompanying memorandum, which the appellant was invited to accept and did accept. However, the manner of appointment is laid down in statute. And then the point is made at 18 that in looking at the content of the relationship, it could be said the terms and conditions contain some provisions, for example, those relating to maternity and paternity and adoption leave, which are not derived from statute. It could also be said that deployment decisions, as in any other employment, may be the subject of some negotiation between the individual judge and the leadership judges in their area. Ultimately, the Lord Chief Justice is responsible for deployment of judges. The essential components of the relationship are derived from statute and are not a matter of choice or negotiation between the parties. And Lady Hale goes on there to identify in particular salary and discipline as being matters laid down by statute. Now, in my submission, there's a further relevance to this case when we come to one of our complaints about the way that both the Employment Tribunal and the Court of Appeal handled this, which is that they treated elements of the functions performed by ULL that it was obliged to perform because it was the holder of a statutory license as a private vehicle, private hire vehicle operator in London, as being evidence relevant and supporting the conclusion that there was a relationship of worker, a contractual relationship of worker between the claimants and Uber London. And we submit that that is wrong in principle, that these are not elements that, in the words of Lady Hale, are a matter of choice or negotiation between the parties. They were requirements of ULL holding its license. And they apply in every single case where a private hire operator works in London and there are drivers driving, taking trips that have been booked by that operator. And as we shall see shortly, there are many cases in which those relationships exist, and it's been established for many years that they may exist on the basis that the drivers contract directly with the passengers and the operator is the agent putting them in touch with each other. And that being so, and the legislative scheme not being intended to preclude that type of relationship, in my submission, the existence of particular functions or rights or obligations on ULL that are derived from that statutory scheme is completely neutral to the question whether there's a relationship of worker or not.
Well, Lady Hale wasn't treating the statutory provisions as neutral. She was treating them as quite material to the question of whether the relationship is contractual or not.
My Lord, you're right that she's making the point that the fact that these essential provisions are not agreed tells against there being any intention to contract at all. My point is that that means that those elements come out of the equation. If you're seeking to say, what's the nature of a contractual agreement? Is it an agreement which in substance looks like a worker contract? Then elements that a party is not applying because of any agreement, but simply because of statutory obligation, a statutory scheme, can't possibly be in favour of such an agreement. And yet they have been weighed in the balance, and in fact a significant element of the reasoning of both the Employment Tribunal and the Court of Appeal for saying ULL is the employer. The fact that ULL has to keep records of the identity of the driver, the fact that ULL has to operate a complaints procedure, that it has to operate lost property. These are all factors, that it has to give an estimate of the fare. These are all factors that were used against Uber to say in substance this is a worker relationship. But in fact, they're not the subject of agreement between Uber and the drivers at all. They're imposed on Uber by statute. And that's a statutory scheme that explicitly has been adopted in a context in which the agency model is an established industry norm. It would be different if you said, well, this is a statutory scheme under which Parliament's saying a private hire operator must employ drivers as workers. So you can only get a license if you employ drivers under a workers' contract, but that's never been suggested. Now, Gillam hadn't been decided at the time of the Court of Appeal's judgment, but in my submission, it is of assistance to Uber's position. The third case that I want to draw to the Court's attention is the Pimlico Plumbers decision. That's at page 1784. Now, this is a case of plumbers working for Pimlico Plumbers, and the question is, are they LIMB workers or not? And the points that were in issue in this case are very different from the point that's in issue in our case. It was never suggested in Pimlico Plumbers that the plumbers didn't undertake to provide any work for the company. That was never suggested. Never suggested that the company was an agent putting them in touch with customers. The questions were, first of all, were they obliged to perform those services personally, or did they have the right to provide a substitute? And secondly, were they in a relationship with Pimlico Plumbers, where Pimlico Plumbers was their client or customer? So it's the second and third elements of LIMB that are an issue in Pimlico Plumbers, not the first. And that in my submission is very important when you look at the reasoning, because a chunk of the reasoning here is devoted to the question whether the right of substitution was genuine. That's not an issue in this case. There is no right for a driver who's signed up to the Uber app to substitute a different driver. Indeed, that would be a breach of the statutory scheme as well as the contract. That's not an issue. And as I've already said, the question at issue here is not whether Uber London was contracting as client of the drivers, but whether the drivers were agreeing to perform any services for Uber London at all. So you can see the issues that I've identified are set out in the head note. And you can also see that there's a lot of stress, as you would expect, given the prominence of the third element of LIMB in this case, on questions about control and integration and subordination, the types of issues that you found discussed in Cotswold, in Red Cats, and then discussed by Lady Hale in her analysis in Bates and Winkelhoff. you can see noticeably some very different facts from our case, including the facts that the plumbers were required to wear uniforms, they operated in branded vehicles, and most strikingly, there was a restrictive covenant that prevented them from working for a competitor after the end of their engagement with Pimlico Plumbers. And before I leave this, you will see briefly at paragraphs 13 to 14, there is a statement that the test for employment under the Equality Act is in substance the same as the LIMB test under the Employment Rights Act. That's at page 1790. So those are the recent decisions of the Supreme Court dealing with LIMB. And that we submit as the legal test that ought to have been applied by the Employment Tribunal in this case. The next question is the role of an appellate court when considering an appeal from an employment tribunal. And I simply want very briefly to flag the point that the role of the appellate court is different and more limited in this context than it is when hearing an ordinary appeal from the county court or the High Court, because an appeal lies from an employment tribunal only on an issue of law, which of course it includes a perverse finding of fact. If an appellate court finds that an employment tribunal has made an error which was material to the outcome of the decision, it is not open to the appellate court to substitute its own view of the facts, and on that basis dismiss the appeal, unless the appellate court considers that there is only one possible outcome. Otherwise, the appellate court must remit the case to the employment tribunal for a rehearing, because the assessment of the fact is for the employment tribunal, not the appellate court. And that was recently reaffirmed by the Court of Appeal in the case of Jaffrey and Lincoln College. It's at page 1573. You can see it in the judgment of Lord Justice Laws. It's page 1583, paragraph 21. It is not the task of the EAT to decide what result is right on the merit. That decision is for the employment tribunal, the industrial jury. The appeal tribunal's function is and is only to see that the employment tribunal's decisions are lawfully made. If, therefore, the appeal tribunal detects a legal error by the employment tribunal, it must send the case back unless A, it concludes the error cannot have affected the result, for in that case, the error will have been immaterial. Note, cannot have affected, not did not in its view, but cannot have affected. Or B, without the error, the result would have been different, but the tribunal is able to conclude what it must have been. So either that it must have been the same or it must have been different. In neither case is the tribunal to make any factual assessment for itself, nor to make any judgment of its own as to the merits of the case. The result must flow from findings made by the employment tribunal, supplemented only by undisputed or indisputable facts. Otherwise, there must be a remittal. And then Lord Justice Underhill to the same effect at paragraph 45, page 1589. And in our submission, one of the flaws in the judgment of the Court of Appeal in this case, which I'm going to come to in more detail later, is that the Court of Appeal recognised that there were errors that had been made by the employment tribunal in this case, but nevertheless chose to evaluate the facts for itself and decide what it thought was the right answer. And that was, in our submission, not the correct approach. That then brings me to the question of the proper approach to the interpretation of the contracts in this case. And the leading case on this is the decision of the Supreme Court in Autocleanse and Belcher, which is in the authorities bundle. And it's at page 744. As the court will have seen, in due course, my submission is going to be that the Court of Appeal misinterpreted the ratio of autocleanse, or in any event, that autocleanse as interpreted by the Court of Appeal is not the law. So I want to look at autocleanse in some detail in order to make submissions as to what was actually decided in that case. And in my submission, there are 3 points of basic principle. The first is that contracts in the field of employment or personal services are contracts. The general principles that apply to the interpretation of contracts apply to them too. And particularly so, where the very question at issue in the case is whether a contract is properly to be regarded as a contract in the field of employment or personal services, or as a different type of contract. We submit that it cannot be the law that if one party alleges that a contract is in the field of employment or personal services, different or special principles of contractual construction apply. That cannot be right. The second principle, equally importantly, is this. The principles that apply to the interpretation of all contracts take into account the particular factual circumstances as at the date the agreement was entered into. And in particular, autocleanse and other cases that are considered in autocleanse consider a particular situation where there's an inequality of bargaining power and where the dominant party has a commercial incentive to record an agreement in writing in terms that do not reflect its actual substance. Now, the first of those points about inequality of bargaining power is explicitly referred to. The second is, in my submission, implicit as underlying the reasoning in this line of case law. But it's not just that one party is dominant, it's that they've got an incentive. Because of the scheme of statutory protection that we looked at a little earlier, there is a commercial incentive to record an agreement that may not accord with the substance of its real terms. Now, that particular factual circumstance may be relevant when the court is seeking to identify what the true terms of an agreement are. And that's always the task of the court in an employment context and in any other context. Of course, a written agreement is never determinative, it's always evidential. There's a risk in that particular situation that what's written down doesn't reflect the actual rights and obligations of the party. So, as a matter of fact, not as a matter of a special or different approach, in that situation, a court may, on occasion, have to investigate the surrounding circumstances and the party's conduct in order to determine whether or not the written terms accurately record the substance of the agreement. That's what they're seeking to do. And that, we say, is not a special principle for employment contracts. Indeed, it's been applied in other contexts too, including landlord and tenant. The classic case of Street and Mountford is an example. This does not mean that written terms in this context or any other context are relegated in importance to being just one factor, or does it mean that the task of the court is to deduce the terms of a party's contract by looking at their conduct, ignoring the written terms. In our submission, the written terms should still be the starting point of the analysis because they are strong evidence of what the parties have actually agreed, because they have both signed up to that document. If the actual operation of the contract shows that the written terms don't reflect what was agreed, then they're not determinative. But that is what must be shown. And a classic example is what happened in AutoCleanse itself, where the written agreement said that the car valeters, in that case, could send a substitute. They didn't have to provide their services personally. But the courts found that, in fact, that wasn't right. They did have to provide their services personally. So the substance of their obligation was, in fact, to provide personal services, even though the contract suggested differently. Now, of course, there are lots of circumstances where conduct may be ambiguous. For example, if a passenger makes a payment to UBV and UBV then makes a payment of the same amount less 20% to the driver, you could interpret that payment just looking at it alone in two different ways. You could say that's a payment being made by the passenger to the driver, and UBV is deducting its commission. Or you could say that's a payment being made by the passenger to UBV, and UBV is then making a piecework payment to the driver who's working for UBV. However, if you've got a transaction that is ambiguous, and you've got a written contract that tells you what that transaction is and how it's characterized, and what the written contract says is perfectly consistent with what the parties are doing, then in my submission, it's wrong in principle to seek to construe the transaction differently. So if, in the example I've just given, you have that payment passing, and you have express contracts that say, on the one hand, the passenger agrees that they will pay the driver and that UBV will be agent, payment collection agent. And the driver has a contract with UBV that says exactly the same thing and says that UBV can deduct a commission. Then there is no reason, and it's wrong in principle, to seek to interpret that payment in any other way.
But you would still be required to ask, wouldn't you, whether the written terms were a complete statement of what the parties had agreed, or whether they were to be judged against the context of other terms and conditions which were not fully set out and which may change the true interpretation of what is written.
Well, my lady, there are obviously different circumstances in which you might supplement the terms of a written agreement. My focus has been on what occurred in this case, which is that the employment tribunal said, well, the written agreement's completely fictional, and we're going to disregard it. Now, you could have had a different situation, which isn't what happened in this case, where the employment tribunal said, okay, the written agreement contains certain terms, but we think that by conduct, there have been variations to the parties' rights and obligations, or we think that the conduct shows that there were other or supplemental terms that were applied. Now, there are cases where that's been done, and that's a method of construction that's perfectly permissible, but it isn't what was done in this case, and it's never what was done in this case. Now, that's going to be relevant later, because as your ladyship will have noted, one passing comment made by the Court of Appeal that's been picked up by the respondents in this case is that at paragraph 82 of the judgment, the majority in the Court of Appeal said, oh, well, you could have two contracts. Just because there's a contract, even if Uber were right and there's a contract between the driver and the passenger, you could still have a contract between the driver and ULL, where the driver is also contracting to provide services to ULL. Now, I'm going to make a number of submissions as to why that simply doesn't work on the facts, because that would be inconsistent with the expressed terms. But a more basic objection is that that's not what the Employment Tribunal found in this case. And that's a factual assessment that would have to be dealt with on remittal. So that's why my focus is here on what the tribunal found, which is these written contracts are to be ignored because they're fictional and they're absurd. That's the finding that I have to meet. So that was the second point about the approach in this particular factual context. The third point is this, that parties in their agreements may record not only the substance of the rights and obligations that they've assumed or are entitled to, but may also seek to characterize or label their relationships. So classically, they may decide that they may purport to say whether an agreement is a lease or a license, or whether a person is an independent contractor or an employee. It's well established that the legal label that parties choose to put on their agreements are not conclusive. If the substance of the terms agreed is on analysis inconsistent with the label that they have attached to the agreement, then the court will proceed on the basis of the substance of the agreement. In substance, what you have is a lease. The fact that you call it a license makes no difference. Equally, though, the fact that parties have characterized their relationship in a particular way, in this case as independent contractor and business, is not a ground for finding that in fact their relationship is something different. Not a point to be taken against the party that they've chosen to characterize their relationship that way. On the contrary, if there's ambiguity so that a relationship might fall within either category, the fact that the parties have expressly categorized it in one way is, in our submission, relevant in their favor and could be determinative. So in our submission, you're looking for two things in a case such as this, where it's alleged that the written agreements don't reflect the reality of the contractual relationship. First, are the terms of the written agreement consistent with the actual rights and obligations assumed by the parties? And second, does an agreement containing those rights and obligations meet the conditions of the legal characterization or label that the parties have sought to attach to it? So that's in my submission, the three basic principles. And I would add to them that on the first question, where you're asking whether the written agreement is consistent with the actual rights and obligations that the parties have assumed, the stress is on rights and obligations. Parties may choose to operate their contracts in ways where they don't necessarily rely on all the rights that they have. The fact that they do that doesn't mean that those rights don't exist. And we'll see in a moment that in AutoCleanse, there's a careful distinction between a situation where a party does have the right to substitute another individual to perform the services, but doesn't exercise it, and where on analysis, the party doesn't have that right at all.
Your whole approach really
Yes.
leaves out of account the purpose of the legislation. You treat the facts as being sort of neutrally out there. The approach obviously favoured by the majority is to look at the purpose of the legislation, which they see as being protective. They say in order, their approach is to say that in order to apply that legislation properly, you have to consider what the reality is of the agreement between the parties, and the written documentation is not necessarily all there is to it. And on the facts of this case, they find that the reality of the arrangement is not reflected in the, or is certainly not defined by the written contractual terms. It's
Yes.
fundamentally a different approach from yours.
My submission, it's not. That what your lordship's just put to me is no different really from my approach. But also that in my submission, it's not right simply to say the statutory purpose is protective. Because as we considered earlier, the statutory purpose is to protect those who have relationships that fall within the scope of the statute. It's not to protect everybody. And we've seen a carefully nuanced statutory purpose where the scope of protection for certain statutory rights is different than the scope of protection for other statutory rights. So you are simply asking the question whether this agreement falls within the scope of Lim B. That's the question you're asking. And that, in my submission, is not leaving out of account the purpose of Lim B. On the contrary, it's faithfully applying the purpose of Lim B, which is, yes, to give protection within its own stated boundaries.
But where there is a protective
Yes.
purpose,
Yes.
and where you see parties in unequal positions, the effective implementation of a statute is going to require the court to be prepared to look beyond the written documentation and to entertain the possibility that the reality of the arrangements may be something different.
My lord, I don't dispute that, but perhaps for a slightly different reason. I certainly don't dispute that when interpreting the contract, the court can, and in many cases should, look beyond the four corners of what's written down. I'm not saying you only look at the written document. The point that I make is that that's not a special principle, it's not a different principle. The application of normal principles of contractual construction to a particular factual situation. And as I've identified.
But the implication of it is that it goes beyond contractual construction. It means that you are not confined to the terms of the written contract as determinative of the actual arrangement between the parties.
Well, we may be slightly at cross purposes because contractual construction is not the same thing as the terms of the written document. And of course, I accept that if you're asking what's the real agreement between the parties, you may conclude that the real agreement between the parties is not that which is written down, or is supplemented, or different from that which is written down. But in my submission, you are always asking what are the terms of the contract between the parties. And it wouldn't be an application of Lim B to go beyond that. It would be, in my submission, an impermissible interference with freedom of contract. Because the way your lordship put it to me initially, the suggestion that this is not just a matter of contractual construction, with that I do take issue. I accept that contractual construction is not the same thing as just looking at the document. But in my submission, this is a question of contractual construction because that's what Parliament has said it is. Parliament, as we've seen, if you go back to 43K of the Employment Rights Act, Parliament didn't have to use a contractual framework to establish the limits of this right. But it chose to do that. It chose to say, you don't have an entitlement to the minimum wage unless you are a party to a contract that has these features. And in my submission, that being what Parliament has said, it is wrong in principle for the courts then to say, we're not limited to the proper interpretation of the party's contract, but we can construe their relationship by some broader purposive approach so as to bring it within the scope of the protection of limb B, because there's a protective purpose. That is the argument that the respondents are advancing to your lordship. And in my submission, it's wrong in principle, because and the reason it's wrong in principle is that it actually subverts the statutory purpose. Because the statutory purpose...
We may be at cross purposes.
We may
I think the only point I'm putting to you is that the written document called the contract.
It's not the beginning and end.
It's not the end of the story.
It's not, my lord. Sorry, my lord, Lord Legate. Yes.
Sorry, I have to wait again. Coming back to auto cleanse, and when you go through it in a moment, my reading of it is that it goes rather further than you're submitting, and that it decides in particular that the rule in Lestrange and Graucob does not apply in this context.
Well,
Nor for that matter the parole evidence rule, as I see it, so that when you are identifying what the parties have agreed, you don't start with a presumption that because there's a set of written terms and conditions, those have been agreed. What you have to find out is whether the parties actually have understood and intended the contents, what a particular term of that document to form part of their relationship. And if, for example, the finding is that the drivers never read these documents, then you may not even get in the door of construing the document, because the parties don't actually understand that what is set out there is their agreement in reality.
But my lord, in my submission, if that is what is said in autoclaims, and in my submission, it isn't what's said in autoclaims, but if it was, then it isn't the law, because it results in the absurd proposition that a completely different canon of contractual construction applies simply where one party alleges that a contract falls within the realm of personal services. So if you have, as you do in this case, a contract which one party says is not a personal services contract at all, but effectively is a license for access to an internet platform, the other party says it's a contract for personal services, that because one party is making that allegation, normal rules of contractual construction go out of the window. Now, in my submission, that's not what the Supreme Court says in autoclaims when you look at it properly. What they're actually saying in autoclaims is simply that this is a factual context in which the written agreement, there's a risk that the written agreement doesn't reflect the real agreement because of the two factors I've identified. One is the inequality of bargaining power, and the other is the commercial incentive on the dominant party to record an agreement that doesn't reflect the substance of the true terms, and that in that situation, as a matter of fact, you may have to make a wider inquiry to see what they actually agreed. That's all it's saying. Not going any wider than that. And certainly, there's no suggestion that Lestrange and Graucob doesn't apply in this context. That would be pretty.
Well, I'm looking when you come to it at paragraphs 20 and 21.
Yes, well, Lord, I'm going to come in detail to it, and your lordships know that my broader submission is, if that is what Lord Clark said, then it ought not to be followed, because in my submission it's unprincipled and wrong. I don't know, my lords, whether that's a good moment for the short break, and then we can grapple with autoclaves refreshed.
I think it's quite a good moment to bring down the curtain for a few minutes, and we can resume in about 5 minutes' time. Thank you.
Right. My lady, before we turn to autocleanse itself, I want to show the court the summary in the judgment of Lord Justice Underhill of his understanding of the ratio of autocleanse, which we respectfully adopt. That's at page 284. You see the heading autocleanse, and then at paragraph 119 over the page, he sets out his understanding of the principles emerging from the key passages in autocleanse. And then at 120, it's an essential element in that ratio that the terms of the written agreement should be inconsistent with the true agreement as established by the tribunal from all the circumstances. Nothing in the reading of the Supreme Court gives the tribunal a free hand to disregard written contractual terms which are consistent with how the parties worked in practice, but which it regards as unfairly disadvantageous and which might not have been agreed if the parties had been in an equal bargaining position. That's really the critical point. That there must be shown to be inconsistency. Now, autocleanse itself, Lord Clark proceeded by approving in considerable detail the judgments of the Court of Appeal in that case, and in particular the judgments of Lord Justice Aikens and Lord Justice Sedley. And I'd like to look first at the Court of Appeal decision in autocleanse. You will find that starting at page 1275. Sorry, 1265. And if we come to Lord Justice Aikens, that starts at 1273. And after setting out the statutory scheme, if we go to paragraph 87, he says, I think it's sensible to consider this point from the first principles of contract law. Express contracts can be oral or written or a mixture of both. And then where they're in writing and it's not alleged that there are any additional oral terms, that I think is the point that my lady was putting to me, the written terms will at least prima facie represent the whole of the parties' agreement. Ordinarily, the parties are bound by those terms where a party signed a contract. If a party has not signed a contract, there are usual issues as to whether he's made sufficiently aware for the court to be able to conclude that he agreed to the terms. That's not an issue in this case. So there we see that there's a reference there to Lestrange and Grabham. Once it's established the written terms were agreed, it's not possible to imply terms that are inconsistent with its express terms. The only way it can be argued a contract contains a term inconsistent with one of its express terms is to allege that the written terms do not accurately reflect the true agreement of the parties. And in my submission, it's that point that is the true ratio of autocleanse, the end of that sentence, the allegation that the written agreement doesn't represent the true agreement. Then at 89, he comes on to the general position in contract law, where he says, well, generally, you would have to seek rectification. And then he says, but in cases of contracts concerning work and services, where one party alleges the written contract terms do not accurately reflect the agreement of the parties, rectification principles are not in point, because it's not generally alleged that there was a mistake in setting out the contract terms as they were. So he's not saying rectification is inapplicable in an employment situation, or that special different principles apply. He's saying it's a different factual situation. It's a different type of allegation. There may be several reasons why the written terms do not accurately reflect what the parties actually agreed. In each case, the question the court has to answer is, what contractual terms did the parties actually agree? He then refers to an earlier decision, and he says at 91, in cases where there's a dispute as to the genuineness of the written terms of a contract relating to work or services, the focus of the inquiry must be to discover the actual legal obligations of the parties. And that, again, we respectfully submit as the correct text. And he says, speaking for myself, I would respectfully suggest it's not helpful to say a court or tribunal has to consider whether the words of the written contract represent the true intention or true expectation of the parties. There's a danger that a court or tribunal might concentrate too much on the private intentions or expectations of the parties. What the parties privately intended or expected before or after the contract may be evidence of what objectively discerned was actually agreed. And he cites Lord Hoffman, but ultimately what matters is only what was agreed, either as set out in the written terms, or, if it's alleged those terms are not accurate, what is proved to be their actual agreement at the time the contract was concluded. It may not be expressed, it may be implied, but the tribunal's task is still to ascertain what was agreed. And then at 92, he points out the difference in the factual circumstances in a contract such as this from a commercial contract. And because of that, and because of the inequality of bargaining power, he says, I accept that frequently organizations which are offering work or requiring services to be provided by individuals are in a position to dictate the written terms the other party has to accept. And then in practice, and I emphasize those words, in practice, in this area of the law, it may be more common for a court or tribunal to have to investigate allegations that the written contract doesn't represent the actual terms agreed. And the court or tribunal must be realistic and worldly wise when it does so. So he's not suggesting that there is some different legal principle. What he's saying is this is a particular factual context where in practice it may be more common for a court have to conduct this exercise. And then where there's a written contract, as Lady Justice Smith pointed out, that must be the starting point for determining the terms of the contract and therefore the nature of the relationship. But where one party alleges the written terms don't accurately represent the actual terms agreed, then the exercise the court or tribunal has to perform is not to find out whether the parties realistically intended or envisaged that its terms would be performed as written. What if one party intended it but the other did not? I would prefer to put the matter as Lady Justice Smith has done. The focus of the inquiry must be to discover the actual legal obligations of the parties. And we would, again, respectfully endorse and adopt the whole of that crucial and important paragraph. And then Lord Justice, the actual facts of auto claims he then deals with briefly, and he makes the key point that the written agreement said that there was no obligation to work and that the car valeters could provide a substitute. But the facts that were found, which were then upheld by the Court of Appeal, were that the true obligations of the parties were that there was an obligation to work and that there was no right of substitution. So that the true agreement of the parties was flatly inconsistent with what was written down. And then yes.
I don't want to keep interrupting
Yes,
to make what's essentially the same point.
Yes.
But I do wonder about the approach of that you're pressing upon us. It really seems to be asking whether terms in the written contract are are real or sham, depending on whether or not they correspond or are consistent with the reality of the way people behave.
Yes.
Now, the approach which is perhaps most clearly exemplified by the tax cases, based on a purposive interpretation of legislation, is much broader than the idea of sham, as explained in cases like Snook. The tax cases illustrate that whether, for example, a given term is material in a statutory context doesn't depend on whether it's real or not. Terms can be real and may be highly relevant for the purposes of one question in tax law, but may be immaterial when you're applying another provision of tax law. Some provisions of tax law may require you to look at transactions step by step, assessing the effects of each of those individual steps. Others may require you to take a broad view of the overall economic consequences of a series of transactions, in which event individual steps fall out of account without categorizing them as unreal or sham.
Yes.
And if one approaches the present issue in that kind of a way, to take as your starting point the written documents and assess whether or not they are sham, isn't going to bring you to the right answer.
Yes.
The whole exercise,
yes, I understand.
ought to be assessing what is the purpose of the legislation, first of all, and we're dealing here with provisions such as the national minimum wage, which are obviously intended for the broadest protection of low-paid workers in our society. And you're then asking whether the relationship between the parties in the present case, viewed in the light of that purpose, falls within the scope of Lim B.
Yes. Two points in response to that. The first is in relation to the meaning of sham. I fully accept that when you're talking about a sham in this context, you're not limited to sham in the Snook context. Very clear that that is part of the ratio of autoclaim, because the Snook sham requires both parties to be in on it as a deliberate attempt to deceive, and that's not the test. The test is whether or not the actual obligations of the parties are inconsistent with those recorded in the contract, which may have been recorded by only one of them. That's the first point. The second point is that I would respectfully submit that your Lordship's broader point is not correct in this context and is not the ratio even of autoclaims. What your Lordship's putting to me would go very significantly even beyond autoclaim, because with respect, it misstates the statutory purpose. The statutory purpose is not that all low-paid workers should receive the national minimum wage. The statutory purpose is defined by reference to contracts that are identified by Parliament as having specific features. And as we saw from the extended definitions, Parliament has in its arsenal other tools for defining the scope of protection. And there are some tax statutes which deal with transactions in a broader sense and that are purposively construed so that what you're looking at is the economic reality of the transaction as a whole. whether it's serving any substantial commercial benefit. That's not the statutory test here. It's not the statutory purpose here. Because what Parliament has chosen to do is to say, if you choose to enter into a contract that has these features, you will have these rights. And the starting point for determining whether you have those rights must be whether or not you actually have a contract that has those features. And that is a question of contractual construction. And my submission, that has to be the right approach. If you start to say, well, if the economic reality of the contract, if the economic reality of the relationship is that you're subordinate, you're integrated, you're vulnerable, you're low paid, you should get the protection of Limb B. That's exactly the vice that Lady Hale deprecates in Bates van Winklehoff, putting a gloss on the statute. And in my submission, it's impermissible rewriting of the contract, not the construction of the contract that's mandated by Parliament. So I suppose the point where I'm parting company from your lordship is on the definition of what the statutory purpose is here. You can't just say it's protective. It's to protect certain categories of people defined by reference to particular types of contract. That was accepted, of course, by both the Court of Appeal and the Supreme Court in AutoCleanse itself, because there's no doubt as to what the task is that's being undertaken in AutoCleanse. It's a task of construction. What you're seeking to discern is what the parties have agreed. Now, I was going to deal briefly with Lord Justice Sedley. That's at page 1276. And at 103, he says he's content to adopt the reasoning of Lord Justice Aikins, recognising as it does that while employment is a matter of contract, the factual matrix in which the contract is cast is not ordinarily the same as that of an arm's length commercial contract. Employment judges have good knowledge of the world of work, the sense derived from experience of what's real and what is window dressing. The conclusion that AutoCleanse's valeters were employees in all but name was a perfectly tenable one on the evidence the judge had before him. The elaborate protestations in the contractual documents that the men were self-employed were odd in themselves, and when examined, bore no practical relation to the reality of the relationship. Contracts began by spelling out each worker was required to perform the services he agreed to carry out in reasonable time and in a good and workmanlike manner, an obligation entirely consistent with employment. Notwithstanding the repeated interpolation of the word subcontractor and the introduction of terms inconsistent with employment, which as the judge found were unreal, there was ample evidence on which the judge could find that this was in truth an employment relationship. His finding did not seek to recast the contract. It was a finding on the prior question of what the contracts were. And again, I would respectfully adopt that analysis. Rightly, it was uninfluenced by the fiscal and other consequences of the relationship, which were by no means all one way. And again, in my submission, I would rely on that proposition in response to my Lord Reid, that the construction of the contracts is a matter to be conducted by reference to contract law and not to be adopted in order to bring the contract within the scope of statutory protection. That's putting the cart before the horse, Mark. So that's the Court of Appeal. And we then come to the decision of the Supreme Court in AutoCleanse, which starts at page 744. And in my submission, it's clear that Lord Clark is not seeking to say anything different from what was said by Lord Justice Aikins and Lord Justice Sedley in the Court of Appeal. On the contrary, he goes out of his way to endorse all of the key paragraphs of their judgments that I've just shown to the court. Now, if we go to paragraph 20, page 751, he starts by saying the essential question in each case is what were the terms of the agreement. And again, we respectfully agree. That is the essential question. Then he refers to the position under the ordinary law of contract, and he sets out various paragraphs from Lord Justice Aikins. And then he says, nothing in this judgment is intended in any way to alter those principles which apply to ordinary contracts and in particular to commercial contracts. There is, however, a body of case law in the context of employment contracts in which a different approach has been taken. And then he says, Lord Justice Aikins put it correctly in the remainder of paragraph 89. Now, in my submission, what's then quoted from Lord Justice Aikins is not saying that this is a special different rule of contractual construction that applies only in the field of employment contract. What Lord Justice Aikins is saying in this passage, which we've already looked at, is you're not looking at the question of rectification here, because the allegation is not that there was a mistake in the recording of the agreement. The allegation is that the agreement doesn't record the true terms agreed by the parties. And there may be several reasons for that. Lord Justice Aikins is not suggesting this is a special approach. Now then, Lord Clark comes on to consider 3 earlier cases, which he does in some detail. And then if we go down to paragraph 29, he says the question is not whether the 2 approaches are consistent, but what's the correct principle. I unhesitatingly prefer the approach of Mr. Justice Elias in Kalwak and the Court of Appeal in Silagi, and in this case, to the Court of Appeal in Kalwak. Question in every case, as Lord Justice Aikins put it, what was the true agreement between the parties? I don't perceive any distinction between his approach and Justice Elias, and so on. And then at 30, he sets out and approves, Court of Appeal has to consider whether or not the words of the written contract represent the true intentions or expectations of the parties, not only at the inception of the contract, but if appropriate as time goes by. And then he adds the clarification of that statement that Lady Justice Smith gave, where she points out, and we see this at the top of page 755, that the question is whether or not the written agreement represents true intentions and expectations, not only at inception, but at any later stage where the evidence shows the parties have expressly or impliedly varied the agreement between them. So she's not suggesting that simply the way that the parties conduct themselves is in and of itself sufficient to alter the terms. And this is the point I was making earlier, that you might have a contract that says a party can offer a substitute. The fact that they don't offer a substitute is not enough of itself to demonstrate that they don't have the right to offer a substitute. The question is always a contractual question. And you see, she addresses that point specifically at paragraph D. The mere fact that the parties conducted themselves in a particular way does not of itself mean that that contract accurately reflects the legal rights and obligations. There could well be a legal right to provide a substitute worker. The fact this right was never exercised in practice doesn't mean it was not a genuine right. So this is all completely orthodox contractual construction being approved here by the Supreme Court in Autoclan. And then Lord Justice Aikins at 32 stressed the importance of identifying what were the actual legal obligations of parties. And then the point that it's not about what the parties privately intended or expected, but what was agreed. And we see Lord Clark explicitly saying that in that paragraph, I agree. He then refers to Lord Justice Sedley and again says, I agree. And then at 34, the critical difference between this type of case and the ordinary commercial dispute is identified by Lord Justice Aikins at paragraph 92. And this is the passage that we've just looked at in Lord Justice Aikins's judgment, which I have respectfully endorsed, where this is not a different legal approach, it's a different factual situation, which in practice more commonly will lead to a different type of investigation. If you've got an arm's length commercial contract between two banks, it's very unlikely that a court is going to be looking beyond it. But because of the particular factual circumstances, including, as I've said, the inequality of bargaining power and the commercial incentive on one party to misrepresent the terms, as a pragmatic matter, you're likely to be conducting more investigation. That's what Lord Justice Aikens is saying, and that is what is here being endorsed. Then we have paragraph 35, which in my submission is the paragraph that could lead to misunderstanding. Because he then says, so the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represent what was agreed. Now, I would respectfully submit that's putting it a little too high, because an inequality of bargaining power might have that effect. It might simply result in the parties genuinely agreeing terms that are very favourable to the party that's dominant. And that might be their genuine agreement. And as we shall see, that's exactly what happens in the Secret Hotels 2 case, that you have a significant inequality of bargaining power. And the result of that is that the agent has terms that are very favourable to them, vis-a-vis the principal, which is the individual hotels advertising on their website. So the mere fact that there's an inequality of bargaining power doesn't suggest that the terms are not accurate. But he does, it's fair to say, only say it must be taken into account. And then he says, the true agreement will often have to be gleaned from all the circumstances of the case, of which the written agreement is only a part. Now, if he's saying there that because of the factual circumstances Lord Justice Aikens has identified that are referred to at 34, you may often in practice have to look beyond the written agreement. I respectfully agree. The difficulty in my submission is that the way this has been interpreted by some tribunals and courts, including in my submission, the Court of Appeal in this case, is that in this type of case, you don't even start with the written contract. You simply look at the relationship between the parties in the round. The written agreement's just one part of the background, and then the court itself deduces what it thinks is the best fit. What it thinks is the best fit of the relationship. And that may lead the court, if there's a genuine ambiguity in the relationship, to deciding that it thinks this is a worker relationship rather than an agency in order to give statutory protection. Now, that in my submission is what's happened in this case. And that's not what Lord Clark meant there. If it is what he meant in my submission, it's not the law. It's certainly not what Lord Justice Aikens was saying, which Lord Clark was expressly approving. And in my submission, that approach is contrary to the intention of Parliament. It's not an application of the purpose of the statute. An impermissible rewriting of the contracts for a teleological purpose, going beyond what Parliament intended. So that's essentially where we quarrel. He then says this may be described as a purposive approach to the problem. If so, I'm content with that description. It's very unclear what he means by that. If what he meant is something along the lines that my Lord Reid has been putting to me, for all the reasons I've already probably wearied your lordships and your ladyship with at too great a length, we submit it's not right. So that is auto-cleanse. And unless there are any particular further questions anyone wants to ask me about auto-cleanse, I want to move on. I should stress I'm going to come later to what the Court of Appeal made of auto-cleanse. But before I do, I want to come to the facts. So our submission, at the end of all that, is that the task of the tribunal in this case was to construe the contractual relationship applicable between the parties in this case in order to determine whether the conditions of Limb B were or were not met. And more specifically, in order to determine whether the first condition of Limb B was met. Did the claimants work under a contract under which they had undertaken to perform any work or services for ULL? So that then brings me to the written terms themselves. And I want to look first of all at the contract between the claimants and Uber BV. There are two sets of terms that the court has in its bundle. The first are the old terms, which you'll see are called the partner terms. Those start at page 486. The provisions of those terms were summarized in the SFI paragraphs 14 to 15. That's in the core volume, it's page 65. I don't propose to look at the old terms in detail. I want to focus on the terms that were current as at the date of the tribunal hearing, which the tribunal calls the new terms. They're actually called the services agreement. And that is in the same volume, it's page 543. Now, I've said these are the terms that were current as at the date of the employment tribunal hearing. I should say they are no longer current, but they're the only terms that we need to consider. Later development, there have been significant later developments, regulatory and contractual, but they're not the concern of this appeal. Now, the overall nature of this contract in my submission is predicated on the fact that Uber BV is the owner of a very valuable piece of software, which is the Uber app, the Uber platform, which is the platform which enables drivers to be put in contact with passengers. I don't know whether all members of this court have taken an Uber. If you have, you will know that if you download the app and you seek to take a trip, you get a lovely graphic showing lots of little tiny cars all moving around the location where you're standing. And what happens is that those little cars represent drivers who are logged onto the app. And when you request a trip, the Uber London accepts your booking and then offers the trip to whichever of those tiny cars is closest to your location. Driver has 10 seconds to say whether they want to accept the trip or not. If they don't, the next nearest is offered the trip, and that's how it works. So what's innovative about the app, in a context, private hire vehicles, where drivers are not entitled to apply for hire, so traditionally are based in the minicab offices, it enables the drivers to drive around and to be close to the passengers who want their services, because the app is geolocating the passenger and the driver and matching them up. So that's the essential background here. And what in my submission this contract is doing is granting a license to the people who want to use the app, subject to conditions. And the conditions for use of the app reflect the commercial value of the app to Uber and Uber's desire to protect its goodwill and commercial interests. So, for example, it will be very detrimental to the value of Uber's app if the cars that were picking people up were dirty or unsafe or uninsured, or the drivers were sexually harassing the passengers. So that's the background. And if we go to page 543, we see that the services agreement says it's a legal agreement between an independent company in the business of providing transportation services defined as the customer and Uber BV. And that's a term that's attracted considerable opprobrium from the Employment Tribunal and the Court of Appeal, because the customer, in most cases, though not all cases, as the tribunal accepted, is an individual driver. There are some undertakings that contract with Uber BV under these terms that have themselves a number of drivers driving for them, but the majority, the great majority of those who enter into this contract are individuals. Now, in my submission, you can quibble with that wording, but ultimately what we're concerned with is not that wording, but the substance of the terms and conditions, the rights and obligations that this contract defines. In any event, on the same page, you can see the definition of driver as the principal employee or contractor of the customer. So the agreement itself recognizes that customer and driver may be the same person, principal. And it's stated that they must be who meet the then current requirements of Uber or any of its affiliates in the territory to be an active driver using the Uber services, whom Uber or any of its affiliates in the territory authorizes to access the Uber services to provide transportation services on behalf of the customer and who has entered into the driver addendum. Now, apart from stressing the fact that the contracts are recognizing that the driver may be the principal of the customer, you also see there the point that this contract is explicitly recognizing that Uber BV's local affiliate may be responsible for setting requirements for the driver to drive and authorizing them to do so. And that's not surprising in the context where the local affiliate is going to be the party that holds the relevant license, as in the case of Uber London in this case. So then going over the page to 544, paragraph 1.17, Uber services. Uber's electronic services rendered via a digital technology platform, on-demand intermediary and related services that enable transportation providers to provide transportation services to users seeking transportation services. Such Uber services include access to the driver app and Uber's related software, websites, payment services, as described in section 4, and related support services systems may be updated or modified. Those are the services that Uber BV is providing to the drivers. And it is not suggested that those services are not provided. Then we see a definition of vehicle, and again, you can see that the vehicle must meet the then current requirements of Uber or any of its affiliates. So you repeatedly see this, the wording in this agreement as recognizing the role of the local affiliate. Then clause 2 is the use of the Uber services. 2.1, you can see that each driver has to have their own ID and can't share it. 2.2, provision of the transportation services. So here is a summary of how the app actually works from the perspective of the driver. And in my submission, there is no inconsistency between what's said here and what happens in practice. On the contrary, as we shall see when we look at the findings of fact made by the Employment Tribunal, every aspect of what's set out here in this written agreement is reflected in the Tribunal's own findings about what happens on the ground. And indeed, in my submission, that's true throughout this contract. Every single express finding of fact made by the Employment Tribunal is reflected in this agreement. So if a driver accepts either directly or through an Uber affiliate in the territory acting as agent for the customer stroke driver, a user's request for transportation services, the Uber services will provide certain user information. So just pausing there, the role of the local affiliate as the booking agent there expressly recognized. So authorization given by the driver for that role to be performed. And we're then told user information will be provided via the app, first name and pickup location. Then the clause goes on to deal with location. Driver will obtain the destination from the user, either in person on pickup or from the driver app, if the user elects to enter such destination via the app. And again, it's accepted by the Employment Tribunal. That's exactly how it works. There was no obligation at the material time, it's not the case now, at the material time, there was no obligation on users of the app to tell Uber their destination when they book the car. They could do, but they didn't have to. So they might simply tell their destination to the driver, expressly recognized in these terms. Customer acknowledges and agrees that once a driver is accepted, either directly or through an Uber affiliate in the territory acting as agent, a user's request for transportation services, the mobile app may provide certain information about the driver to the user, including first name, license plate, and so on. Customers shall not, and shall ensure all drivers do not, contact any users or use any personal data for any reason other than the purposes of fulfilling transportation services. So the limitation on contact, again, expressly in the agreement with Uber BV. And you can see the commercial rationale for that from Uber BV's perspective in terms of data protection issues and customer confidence issues. As between Uber and customer, customer acknowledges and agrees, customers and drivers are solely responsible for determining the most effective, efficient, and safe manner to perform each instance of transportation services. Customers should provide all necessary equipment, tools, and other expenses, customer's own expense, necessary to perform transportation services. Again, that's exactly what happens. Everybody agrees that the car is provided by the driver. It's insured by the driver. They pay for the fuel. They pay for their own private hire vehicle driver's license. They incur the economic risk. Then customers' relationship with users. Customer acknowledges and agrees that customers' provision of transportation services to users creates a legal and direct business relationship between customer and user, for which neither Uber nor any of its affiliates in the territory is a party. So there's the direct contract being entered into through the agency of Uber London. And the customer has to provide insurance. Then over the page, 2.4, customers' relationship with Uber. And it said that Uber and its affiliates do not and shall not be deemed to direct or control customer generally or in their performance specifically, including in connection with the operation of the business, provision of services, acts or omissions of drivers. Whilst authorised to provide transportation services, customer and drivers retain the sole right to determine when and for how long each of them will utilise the app. Customer and drivers retain the option to decline or ignore a user's request or cancel an accepted request, subject to the then current cancellation policies. So that's the reference to control, and it's specifically in the context of there being no obligation on drivers ever to switch the app on at all. And once they switch the app on, no obligation on them to accept an individual request. And in my submission, the question of the obligation once the app is switched on, I'm going to return to because it's a matter of controversy. But it is entirely accepted that there is never any obligation on anybody who's signed up to this app ever to use it. Then there's a prohibition on displaying Uber's branding. Then there is an entitlement to provide services at any time to any third party separate and apart from transportation services. For the sake of clarity, customer understands, customer retains the complete right to provide transportation services to its existing companies, customers and to use other software application services in addition to the Uber services. Again, it's not suggested that's a sham. Accepted that all of the people who sign up to this agreement have the right to use any other software app providing transport services at the same time. Uber retains the right to deactivate or otherwise restrict customer or driver from accessing or using the driver app or Uber services in the event of a violation of this agreement, a violation of the driver addendum, customers or drivers' disparagement of Uber, customer or driver's act or omission that causes harm to Uber or its affiliates' brand, reputation, or business. And there's then a general discretion to deactivate. So that's Uber BV's right, not ULL's right. And indeed, ULL wouldn't be in a position to deactivate because the operation of the app is under the control of Uber BV. Then there's customers' relationship with drivers at 2.5. Then we have ratings at 2.6. And there's a provision at 2.61 for mutual rating. The drivers rate the passengers and the passengers rate the drivers. Now this, as you'll see, is heavily relied on, particularly by the Court of Appeal, as a factor indicating effective control by ULL and therefore relevant to the classification of this as a worker contract. First of all, this is a condition of access to the app, not a contractual obligation to ULL at all, but to UBV. And secondly, this type of mutual rating is a completely standard feature of every internet intermediary service. They all have it. And it has to be provided for in this agreement because of the data protection implication. And at 2.6.2, there is express agreement by the customer that if their rating falls below a specified minimum, they can be deactivated. Again, you can understand why Uber BV would want that provision in to protect its commercial investment. But it is not in Uber BV's interest to have drivers using its app who are poorly rated. And then at the end of 2.6.2, additionally, customer acknowledges and agrees that repeated failure by a driver, note that repeated failure by a driver to accommodate user requests for transportation services while such drivers logged on to the driver app creates a negative experience for users of Uber's mobile app. Accordingly, customer agrees and shall ensure that if a driver does not wish to provide transportation services for a period of time, such driver will log off of the driver app. Now, this is critical because what we see here is two contractual terms, which the third respondent says are mutually inconsistent, which with respect are not mutually inconsistent at all, and which clearly set out the scope of the obligations as actually operated. First of all, as we've seen at 2.4, drivers never have any obligation to switch on the app. And secondly, when they have switched on the app, they have no obligation to accept a trip that's offered to them. They can ignore it. After 10 seconds, it will be offered to someone else, or they can decline it. What 2.6.2 is saying is, it's bad for our users if they can see on their graphic what looks like 3 little cars circling around very close to where they're living, but then they're told it's going to be 15 minutes before a car can pick them up. That's very frustrating because it looks like there are cars available, but those cars are not responding. So what Uber is saying is, if you don't want to drive for a period of time, please will you switch your app off? So if, for example, you've stopped at a cafe for a sandwich you shouldn't leave your app switched on in the car. That's what this is getting at. It is not an obligation to accept any individual trip. And indeed, it specifically says repeated failure. And as the court will note, again, this is a provision explicitly in the written agreement. When we come to the tribunal decision, you'll see the tribunal behaves as if it's a gotcha moment, because Uber operates a policy whereby it will take action against drivers who over a prolonged period of time have very low acceptance rates in the region of 30% or 45%. It says, aha, that shows that the right to refuse a trip is nominal only. It shows no such thing. It shows that this contract was being implemented precisely in accordance with its terms. So that's 2.6. Then at 3.1, you see over the page, this is page 548, drivers and vehicles. And there's a whole set of requirements for the quality of vehicles, driving licenses, and so on that you would expect. And again, the right to deactivate if they're not met. And vehicle requirements, which include again, envisage the prospect that the affiliate in the local territory might apply additional requirements for vehicles. That's expressly envisaged at 3.2. Then documentation that must be supplied, set out in detail. Again, in relation, and again, you see explicit reference to the affiliate in the territory. And then financial terms at 4.1. Customers entitled to charge a fare calculated based on a base fare amount plus distance as determined by Uber using location-based services. So the fare is calculated by a mixture of time and distance. And we see explicitly that the customer appoints Uber as the limited payment collection agent solely for the purpose of accepting the fare, applicable tolls, and applicable taxes and fees via the payment processing functionality facilitated by the Uber services. So it is Uber BV that accepts the fare paid by the passenger who registers with it and then pays it to the driver. There is no suggestion that this system didn't operate exactly as it's stated here. There's no evidence to that effect and no suggestion that it did. Exactly what was done. And then over the page, there's a right to charge less, which the tribunal found was nugatory, and one can readily see that it might be pretty unusual for a driver to agree to charge less. And then Uber agrees to remit the fares on at least a weekly basis, the fare less the applicable service fee. Again, the evidence is that's exactly what happened. Then 4.2, there may be different calculations based on local market factors. And then at 4.3, Uber has the right to adjust the fare in a particular instance. For example, if the driver took an inefficient route or failed to properly end a particular instance, so on. So if you've got a fare that's being calculated by a mixture of time and distance, you may get a situation where the passenger complains to Uber that the driver took the long way round and therefore they were overcharged. And in that situation, Uber reserves the right to adjust the fare. Again, you can entirely see why it would want that right. Then 4.4 is the service fee, which is a percentage commission charged on each fare. So the position is that Uber is not paying the drivers for any services. The passengers are paying the drivers through the express agency of Uber. Uber is remitting that money to the drivers less an agreed commission. That's a completely orthodox agency relationship. And that's exactly how the contract operated in practice. No one suggests differently. Then cancellation charges. If the user cancels more than 5 minutes after the ride has been accepted, a charge of £5 can be made. And again, that is paid to the driver, less Uber's commission. Then there's the generation of receipts to the driver at 4.6, sorry, and to users. And that's the receipts are issued by Uber, including the breakdown of amounts charged to the user. Transportation services may include specific information about the customer and applicable driver, including entity name, contact information, name and photo. Then clause 5, we see the actual software license, the license to use the software. There are provisions concerning confidentiality and so on. Then at 13.1, this is page 556, the relationship of the parties. And here's where we find the parties expressly agreeing that it's not an employment agreement, doesn't create an employment relationship between Uber and a customer or any driver, no joint venture, etc. Now, as I've already said, that label is obviously not conclusive. Question is the substance of what's in this contract genuinely the agreement? And is that agreement genuinely to be characterized as Uber says? But what I submit is not right is to take this against Uber and say, because they've sought to characterize this as not an employment relationship, therefore it must be one. Or that's a factor in favor of it being one, because their armies of lawyers are out. Then at 14.1, Uber has the right to modify. 14.5 is an entire agreement clause. And 14.6, no third-party beneficiaries, save where this agreement expressly confers rights on Uber affiliates in the territory. So once again, this contract is explicitly recognizing the role of the local Uber affiliate as having rights under this agreement. So that's the agreement, the written agreement between the drivers and Uber. If you then go on to 559, you see the driver addendum. So this would apply in circumstances where customer and driver are not the same person. And we don't need to look at it in detail. It's in substance the same key terms that we've just been looking at. And there is also a contract entered into between passengers and Uber. And that contract starts at page 579. I think we can just look at it before we adjourn for lunch. And you can see that this is a contract between the passenger, Uber BV, and the local affiliate, in this case, Uber London. And they're all defined on page 579. And we see at 580 that Uber UK, this is clause 3, Uber UK, that includes Uber London, accepts private hire vehicle bookings, acting as disclosed agent for the transportation provider as principal. Such acceptance by Uber UK as agent for the transportation provider gives rise to a contract for the provision to you of transportation services between you and the transportation provider. Now, this, of course, is not an employment contract or a worker contract. Nobody alleges that it is. It's a consumer contract for the provision of consumer services and a license to use the app. And what is being said very clearly here is the transportation contract is through the agency of Uber London, and the agreement is directly with the driver. And it must follow from what the tribunal and the Court of Appeal have said, that this contract is to be disregarded as well, even though nobody suggests that this is a contract for personal services or an employment contract. That's one of the reasons why in our submission you can't have some special contractual construction rules applying only to contracts in that field. It's incoherent. Then provision of booking services by Uber UK. That's clause 4, page 581. And the services that are enumerated there are, in essence, the services ULL is required to provide under the statutory regulatory scheme. Then if you go over to 584, you see the license. Then at page 586, user accounts. This is the provision whereby you have to give your credit card or debit card details to Uber. Then there are conditions on the user for their requirements and conduct, which you see at 587, again, for the commercial protection of Uber. So you're allowed to send children unaccompanied in an Uber, and you're not allowed to let other people use your account. Then payment at 589, clause 4, you will see exactly the same provision that we've just seen in relation to drivers. That payment is directly from the passenger to the driver through the agency of Uber BV as payment collection agent. Then at 591, repair or cleaning fees. So Uber has the right to charge the passenger if the car needs to be cleaned after they've been in it. And essentially, those are the key terms of the rider provisions. So, my lords, with your permission, that would be a convenient moment.
Thank you very much, Ms. Ramsey. We'll adjourn now then and resume at 2 o'clock.